Alright everybody, thanks for joining me. It is Josh, Metro First Realty of Edmond. I'm super excited to go over this part of the 5-part seller series. This part is a real eye-opener to sellers when they're selling their home, and it will also give you indications of if the buyer's agent, I don't care how long they've been in the business, if they actually read the contract. You would be amazed at how many buyer's agents don't actually read the contract, and I'll point out those points that you as a seller will be able to look at and get an indication of if the buyer's agent is actually reading the documents. They're just filling the blanks in on. Now guys, I'm not an attorney. This is not legal advice. Seek legal consultation anytime you're dealing with contracts. I'm just giving you a real estate agent's perspective of the purchase contract that the Oklahoma Real Estate Commission has put together. And the commission is there for the consumer. The consumer is the buyer, guys. It's not the seller, it's the buyer. So to get a copy of your purchase contract, go to the Oklahoma Real Estate Commission's website. That's ok.gov/OREC. ok.gov/OREC. And then go over here to where it says contracts, forms, and related addenda. So I click on that. And then this is the contract right here that everyone's going to be using. If they're not using revision 2019 January 2019, then they're using an old contract. So this is on this contract only. This is what this video is on. Any other contract, and even this video contract, like seek legal advice. I'm not an attorney. So click on it and it will open up for you right here. Now this is the very first thing to let you know if the buyer's agent actually reads the contract. So this is the acknowledgement confirmation page. You just want to make sure that you've already given the buyer's agents the residential property condition disclosure or disclaimer, and if you're just selling land, then it's exempt and the disclosures are not required underneath the Residential Property Condition Disclosure Act. So, and if you're selling a property 1978 and older, make sure you gave your buyer the lead-based paint agreement, or if the property is built after 1978 and thereafter, then they don't need the lead-based paint agreement. So scrolling on down, right here, contract documents. Okay, it says contract documents. This contract is defined as a document with the following attachments. Okay, what is so funny, and I see this all the time from agents who are like, well, I've always done it that way. Well, that's not a real answer. That's an answer that shows your unwillingness to actually read the contract. So if you're a seller and you've got this box checked right here and the agent wrote cash, you're already working with an agent that didn't read the contract. There's no such thing as a cash attachment. That doesn't exist. The conventional loan attachment, that's an addendum made by the Real Estate Commission. FHA loan addendum, that's an addendum made by the Oklahoma Real Estate Commission. There's assumption paperwork that's made. There's seller financing paperwork made by the Real Estate Commission. All of this stuff is made by the Real Estate Commission as an addendum for an attachment. There's no such thing as a cash attachment. So if the agent checked that box and wrote cash right there, automatically you know you're dealing with the buyer's agent that doesn't read the contract. So keep that in mind. The reason that there's no such thing as a cash attachment is the contract right here on clause 2. It says it's a cash transaction. Like, unless one of these addendums are attached, the buyer is buying the property with cash. Do you see that right there? Cash. Okay. So as a seller, if you own the minerals, you want to make sure to reserve them, because look at this clause right here. Together with all fixtures, improvements, apparatuses subject to existing zonance, ordinance, plat, deed restrictions, utility easements, serve the property, including all mineral rights owned by the seller. So if you own the minerals, reserve them. Reserve them. Don't sell your surface rights and your mineral rights. That'd be crazy. Earnest money, you can put up to 5% right here if you want. If the person's doing a conventional loan, why not put up 5% earnest money? The buyer gets it refunded based on clause 7. So looking at clause 7, the buyer gets to inspect everything, and then they get to, and this is a condition. So if your buyer's agent in clause 17, in clause 13 writes subject to inspection inspections and appraisal, they're not reading the contract. They're not reading the contract. Clause 7 right here says buyers shall have blank days to complete any investigation, inspection, reviews. Seller shall have all the utilities turned on for the buyer, and then that's what that clause says. And then right here, look at this, clause 7C 2A. If someone wrote subject to inspections on clause 13 of the contract, they're not reading the contract. Look at this clause right here. If in the sole opinion the buyer's results of investigations, inspections, and reviews are unsatisfactory, the buyer may cancel the contract by delivering written notice of cancellation to the seller and seller's broker, if applicable, and receive earnest money. And this whole clause 7 sets up timelines to keep the buyers on track for getting the inspections done. So if a buyer's agent writes subject to inspections and appraisal, clause 7 already covers it, and appraisal is covered in the financial addendums up here, right here. Conventional loan, FHA loan, VA loan. Those are covered. Those are covered. So as a seller, you already have knowledge of if the buyer's agent reads the contract. So keeping this on a seller centralized video, clause 4. Everything in here goes with the property. If there's something in clause 4 that you don't want to go with the property, put it down here in clause B. Okay? Put it down here. Because all these items go with the property. You can get your own copy of this contract. Just email me, josh@marketing405.com. I'll send you a copy of the contract, josh@405.com, that comes from the Real Estate Commission. And then you want to make sure that the buyer already has your residential property condition disclosures if you're working with an agent. And then investigation, inspection, reviews, this sets out the buyer's timeline to do the investigation, inspection, reviews. If the buyer goes past that timeline in clause 7, they're accepting the home as is if they haven't already canceled the contract. So keep that in mind also. Risk of loss. If the property is burned down due to lightning or hail, that's not within your control. That's an act of God, and then the contract's just null and void. Acceptance of the property. Upon accepting, the title or transfer of possession of the property shall be deemed to have accepted the property in its condition. No warranties expressed or implied by the seller's brokers or their associated licensees with reference to the condition of the property shall deem to survive the closing. So once it's closed, it's the buyer's property. So, hot water tanks can go out after closing. That's the buyer's issue. And if you have some sort of weird agent calling you after closing about something that happened to the house, it's accepted. Like, you guys went through the transaction. Okay, title, evidence, buyer's expense. The buyer buys those things. Seller's expense. So Oklahoma is still an abstracting state. So you'll, as a seller, according to the Oklahoma Real Estate Commission, you'll have to update the abstract and give that to the buyer. Land boundary survey. If someone shows up and they're measuring your house while your house is under contract, it's because you agreed to let that happen. You agreed to let the buyer have a surveyor come out and do a mortgage inspection report or a survey on the property. So if there's someone out there measuring your property as a seller, let them do it. You've agreed to it. Right here, clause 10C. You've let that person do it. Once the title report is done by a title company, you're going to get it. They'll send it out to the buyers and the sellers. If they don't send it out to the buyers, you got to make sure as a seller that they send it out to the buyer. If anything comes up on the title report, you have time to correct it right here. Taxes, assessments, or prorations, they prorate it. In Oklahoma, you pay your real estate taxes in the arrears. So if you close June 30th, you're going to credit the buyer 6 months real estate taxes on the settlement statement. Residential service agreement. A lot of agents click right here and then they put something like $600 in here and then they say the seller has to pay all of it. Well, that's not true. The buyer can buy it at their own expense. You can split it with them, etc., etc. Negotiation, sky's the limit right there. So pay attention to that clause. And then once again, we've already talked about clause 13 and weird things that buyers agents could write in there. Mediation. If this contract starts to go sideways, you've agreed to mediate it. And the Oklahoma State Supreme Court offers mediation for only $5 a person. Now, granted, it is a $5 mediator, but it's there. It's there, and it's only $5 a person, super inexpensive. Talks about breach and failure to close. If the buyer doesn't close, you can hold them liable up to 5% of the purchase price or any any remedy at law. You know, if you as a seller decide you can't sell or you don't want to sell, the buyer can actually force you to sell. So keep that in mind. Don't sell your house unless you actually want to sell it. And then the termination date, if the buyer only gave you till 5 p.m. to sign this, if you're going to counter, that 5 p.m. timeline doesn't matter anyways, because you'll null and void their offer when you counter. But if you are going to accept it, you need to hurry up and accept it, because if you accept it after that timeline, then the buyer has to still agree to buy it based on these terms, because it terminates. So keep that in mind. So that is a summary of the Oklahoma real estate contract. This could be a full week seminar on the ins and outs of this contract. This is just a brief summary to get you a little familiarized with the contract and to let you know whether or not the buyer's agent representing the buyer actually reads the contract. So thanks, guys. Josh, Metro First Realty of Edmond. If you're thinking about selling your home, give me a call, 405-315-7965. If you want a copy of this contract, just shoot me an email, josh@marketing405.com, and I'll get that sent over to you. Like the video, subscribe to the channel, and everything real estate. Tell everyone you know to give me a call, 405-315-7965. Have a great day, guys.